so that background.
Okay.
Yes. The application under consideration is anchored on a writ which the applicant caused to be issued on the 24th of January 2022, invoking the original jurisdiction of this court for the following reliefs. 1, a declaration that upon a true and proper interpretation of Article 94, Clause 2, Paragraph A of the Constitution 1992 of the Republic of Ghana, at the time of filing his nomination form between 5th to 9th October 2020 to contest the 2020 parliamentary elections for the Asin North constituency, the first defendant was not qualified as a member of parliament. 2, a declaration that upon a true and proper interpretation of Article 94, 2, Clause A of the Constitution 1992 of the Republic of Ghana, the decision of the second defendant to permit the first defendant to contest parliamentary elections in the Asin North constituency when the third defendant owed allegiance to a country other than Ghana is inconsistent with and violates Article 94, 2A of the Constitution of the Republic of Ghana, 1992. 3, a declaration that upon a true and proper interpretation of Article 94, 2A of the Constitution 1992 of the Republic of Ghana, the election of the first defendant as member of parliament for the Asin North constituency was unconstitutional. 4, a declaration that upon a true and proper interpretation of Article 94, 2A of the Constitution 1992 of the Republic of Ghana, the swearing in of first defendant as member of parliament for the Asin North constituency was unconstitutional, null and void, and of no legal effect. 5, any further orders and all directions as the court may deem fit to give effect or enable effect to be given to the orders of the court, unquote. And the relevant antecedents to this application can be summarized from processes filed as follows. The first respondent was elected. First respondent is Gyakye Quayson. Okay. Was elected member of parliament for the Asin North constituency on December 7th, 2020. After the election of the first respondent, the applicant on 30th December 2020 petitioned the High Court Cape Coast and contended that at the time of the filing of parliamentary nomination forms by the first respondent, he held Canadian citizenship and was therefore in violation of Article 94, 2A of the Constitution and other electoral laws. The applicant sought various declaratory reliefs: an order annulling the election, perpetual injunction, restraining the first respondent from holding himself out as member of parliament elect for the Asin North constituency, and an order directed at the third respondent to conduct fresh parliamentary elections in the Asin North constituency. On 6th January 2021, the High Court granted an interlocutory injunction restraining the first respondent from holding himself out as a member of parliament elect for the Asin North constituency within the central region, and further from presenting himself to be sworn in as member of parliament for Asin North constituency as such until the final determination of the substantive petition filed against him by the applicant. A copy of this ruling is attached to the applicant's affidavit in support of this application as Exhibit MAN3. Subsequently, on 28th July 2021, the High Court gave judgment after trial in favor of the applicant and declared the election of the first respondent as null, void, and of no legal effect whatsoever. Further, the High Court granted an order of perpetual injunction against the first respondent from holding himself out as a member of parliament for the Asin North constituency. Aggrieved by the judgment of the High Court, the first respondent appealed to the Court of Appeal Cape Coast, seeking to set aside the judgment of the High Court. It is against this background that the applicant commenced the present suit and has mounted this application, deposing at paragraphs 7, 8, and 9, these are for the interlocutory injunction. So, but you've seen.
I get your point.
Yes. So, I don't know. This is our country. It's not my work. I can forward this ruling to you online. You can read it a million times.
The suggestion was that perhaps you had not read the judgment, so
yes.
you were being misled by other people into thinking that the judgment was not in tandem with the principles that you actually espoused.
Well, I wish you were here. My point, and this is sufficient for the point I was making, that the Supreme Court, finally they gave judgment on the matter, still declaring that at the time he filed, Gyakye Quayson filed his nomination papers, he was a Canadian citizen, was not qualified, and the Electoral Commission erred in, so his election was null and void after that judgment. So what is the difference? It declared the judgment in the terms of this High Court judgment, the relevant parts I've quoted to you. I have that judgment. I can bring it to you.
No, I get that.
Yes. So I don't know, whatever. You see, look, one thing. That's why some of us don't move around, and the kind of politics that has entered some people's minds and changes their systems to such an extent that there's no respect for truth, morality, fear of God, anything, except to attain a political objective, fair or foul. This is the kind of mindset that leads to these sort of things. And I'm seriously against that. That is the trust of my life. Yes.
So you were not skewed? You did not misjudge?
Where? I mean,
you did not misconstrue?
At all. At all. But all I was saying was that they purported to re-adjudicate the same case which the High Court had adjudicated. In law, you don't determine the same matter all over again twice. The same parties, the same issues. And I think he was trying to say that their writ in the Supreme Court was about interpretation. That's why I say that judgment, bring it. They went the whole terrain from the time he filed his papers to the time of the election, and the declaration in his favor that he was elected. They went all over that and came to the conclusion that since at the time of filing, between 5th and 9th October 2020, he had not received his certificate of renunciation of Canadian citizenship, he could not have been accepted to contest, and therefore his election was null and void. That is, so I don't know what this man is trying to say. Well, I don't want to use Hatchland normally.
I get your point. It just sounded to many people that he believes and he's of the view that no, you got it wrong. You probably did not know what you were talking about, and that you had not spent a smart time. And he kept on insisting that people should read the judgment, and that you had not spent a smart time perusing it, mindful of your competence in the law.
I'll bring that judgment. I'll have it. I can bring it.
But is it that people do not understand, or we do these things deliberately?
That's what I'm saying. I mean, look, I don't like to talk about people, but try to know a bit about the political background of people when they are talking on issues. And you can see whether that background influences and directs what they say. I may be wrong. I've been a private lawyer and a judge for many years. Politics, I went into it very briefly and opted out because of the nature of it.
I see.
I've said this on platforms before. Now, look,
So which party were you presented there?
That time it was called Popular Front Party.
So there you have it. Former Supreme Court Justice William Atuguba saying the appointment of judges into the judiciary should be based on merit, among many other matters that he talks about. He also talks about the Gyakye Quayson ruling and makes certain core points. He also talks about politics or the influence of the executive as far as the selection of judges or justices of the Supreme Court are concerned and where their leanings could be. Well, joining us for a conversation on that, we have Kweku Paintsil, a lawyer. Mr. Paintsil, a very good morning to you, sir.
Good morning.
It's good to have you join
good
this.
Morning.
Can you hear me, Mr. Paintsil?
Thank you. I can hear you very well and very clearly.
All right. Thank you so much for joining us this morning for a conversation on this matter. Did you listen to Justice Atuguba and probably everything he had to say? Have you had the benefit of listening to the full haul of it? Or is it just what we've aired this morning that you've heard?
Well, what you aired this morning together with bits and pieces on social media, but I haven't got the whole document or the whole presentation that he made. But it appears to me it's been broken down in various bits on social media, aspects relating to this, aspects related to Atuguba, aspects related, all manner of things. So it can't compare to, of course, having the whole of the presentation, but I've heard enough to be able to comment as appropriate.
Right. I mean, you've had a fair idea. That is good because there are a lot of these bite-sized pieces that we've put on social media and on other platforms have been captured. But for you, from where you sit, what do you make, in essence, of everything he said? I just want a summary of your thoughts on what this doyen of the law has said, and then we can take them apart piece by little piece.
On the whole, I don't really see he has said anything new. Everything that he has said relates to matters that have happened in the Supreme Court, places and debates and various points in time, all of these issues, except that he has taken a different time and period to speak about the same things that occupied and dominated the public space. So it's really nothing new. It's just the timing. Just the time rules. There were heated debates, except a few things possibly that he himself has revealed, which of course were not in the public domain. But when it comes to that, we can respond. But on the issue of Gyakye Quayson, on everything that he has said, which were matters that transpired in the Supreme Court or the High Court, there have been arguments both ways. I mean, and so in fairness, I would say that he hasn't said anything really new. Nothing new.
Now, in terms of not saying anything new, would it then be that it is because there's no novelty in some of the things that we have suspected, some of the things that have been bandied about, some of the things that have been said? Is that why you feel there's nothing new in there, essentially?
No, you see, take the issues one by one. If he takes the issue of Gyakye Quayson, what he read, being the fact that there had been a trial in the High Court that had reached a certain conclusion, and the matter came back to the Supreme Court, or rather was raised in the Supreme Court. There were heated arguments, both in the court and outside the court. And eventually the Supreme Court ruled. Right or wrong, when the Supreme Court has got a firm view on an issue, they state it. Either there is a majority and minority, or there is unanimity in decisions that they make. And once they made a decision, it's open them for public commentary. And like I said, this argument, I remember I myself on this particular program has had occasion to talk about my view of the matter. The Supreme Court chose a particular point in time, that is to say, at the point that he submitted his nomination, or he picked his forms. That's the point at which the Supreme Court said was the point to determine whether he had loyalty to Ghana or to another country. So in one sense, he cannot say that the High Court had already made a determination and the Supreme Court also reiterated or virtually repeated the thing. Nonetheless, that will say that Gyakye Quayson owed allegiance to another country was scandalous or was, for some reason, in his view, unacceptable. The court took a decision, which, as you say, came back to the Supreme Court, and the Supreme Court reached the same conclusion. Does he accept, for instance, that at the time that Gyakye Quayson picked the nomination form, that is the relevant point in time for determining whether he had fulfilled the requirements for contesting for elections, and not at some later point in time when he claimed or purported to have now renounced his citizenship? I mean, we have gone through all of this, so I'm really wondering. I mean, like I'm saying, he just happened to have delivered a paper at some seminar, and he has raised this same issue. But it's not as if he's not even aware of the debate and the argument that followed. He's just telling us where he stands on these issues, and that's why I believe that he has really said nothing new. I mean, come on, there are many things concerning. I mean, and of course, now that we know he's retired and now he's on social media or listening to social media, he must have heard comments about the fact that Gyakye Quayson himself, this is not the first time that he came to stand for election. So, so the real issue is, what is it, or what was it in his mind that made him calm down? I understand that by the third or the fourth time. So at all those previous in time, what was he contemplating? Was he waiting up to a certain point in time? So you see, the Supreme Court, when they sit in a way, in a capacity as to stamp certain, their authority, not only their authority, but they must lay down very fair Gyakye Quayson, who come down every 4 years to stand for election, knowing they've not renounced their citizenship. And then somewhere in the line, possibly when they assess their chances, then at that point that they assess their chances that maybe they are likely to win, at that point, the relevant issue is at the point that you pick the nomination. Were you a Ghanaian? Were you a dual citizen? And so forth and so on. These are the issues. And like I said, with due respect to my Lord, if he takes the view that he takes, he's entitled to it. But I, for instance, disagree with him, notwithstanding the fact that possibly I've not reached the height that he reached and so forth and so on. This is not only law. Obviously, the law also reflects the politics of our country, and everywhere you go in the world, that is it.
Just hold for me there. Hold for me, Mr. Paintsil. You just said something that piqued my interest. You say the law reflects the politics of the time in any part of the world. Can you explain that?
There are theories of law in jurisprudence. We've got various theories. We've got, for instance, the Mazes theory of the law. We have that. But in particular, with reference to what my Lord said, we've got what they've got the American realist theory of law. The American realist theory of law is that judges are influenced by their background, their social surroundings, where they grew up, the schools that they went to, and possibly their political leanings. But undoubtedly, it is very clear from Justice Atuguba's own submissions that he has a political leaning. He was talking about PFP.
Hello? Yes, well, he did make mention of the Popular Front Party and also shared his affiliation with them. We're also looking at the political angle because then he made mention of the fact that the executive seems to have some influence on the judiciary in some of his comments. If I may read verbatim what he said as we try to get Kweku Paintsil connected with us again. I'll just read that portion. Let me quickly find it there. He says, the notion that the Supreme Court is politically tilted towards the MPP has some truth in there. Mr. Paintsil, are you back with us? Can you hear me? All right, so we'll try to get Kweku Paintsil connected. Kweku Paintsil, you were making a point and then you went off. You were making reference to the American system and politics. Please go ahead.
Yeah, the American realist theory of law says, for instance, that judges, when they sit to deliver judgment, they are influenced by their background, they are influenced by their political, and they are influenced by the schools they went, they are influenced by
the society that they keep, and so forth and so on.
Are they also influenced by the law and what it says?
Well, the law is there, but that theory, for instance, means that at the end of the day, what a judge puts out is a rationalization. In other words, a judge starts from a position of his views on a particular subject and then tries to pull the various authorities and the various arguments in order to justify his conclusion. That's essentially what American realist theory of law talks about. And that is the impression that Justice Atuguba himself is telling us. He is talking to us about judges being influenced by their political leanings. And obviously, everybody has a political leaning.
Yes, but to the extent that one's political leanings do not weave into one's reflections on the spirit, the letter of the law, is that not the case? Political leanings are there, like we're told. Every man, every woman is a political animal, if you read the political science. Yet, in the law, you must be able to shed the cloak of politics and put on the cloak of the law and what it says. Is that not the case?
That is the case, and that is what ought to be the case. That is what ought to be the case. But even when we talk of in the advanced democracies, it's important we draw the distinction or even make those references. In America, there's always a quarrel about conservative judges and liberal judges. There's always. And about appointing, because they know the view. If you're president and you lean towards abortion, you know what kind of judges that you must get to sit in the Supreme Court and so forth and so on.
It is true. We saw that in the overturning of Roe versus Wade. But I insist that even the American judges, whom we know either come from conservative or liberal stock, still apply the law beyond all these things that we're talking of. We know the Republicans and their stance on guns, arms, munitions, and abortion. Yet we also see these judges applying the law and sometimes going against the very grain, the very tenets, for example, of Republicans when they are conservative. Kweku Paintsil, we'll try to reconnect with him and get his thoughts on that matter. I just had to intervene there because he's making mention of the American system. But the American system, while it may be more aligned, if you want to say so, also has its own... Mr. Paintsil, so the point I was making, while it may be that we know that conservatives, Republicans, and their views on abortion and guns and all of that are there, by and large, the rulings reflect the law, what the letter of the law says, and sometimes go even against what Republicans would lean toward. How do you reflect on that?
Oh, that's a fact. I mean, that's a fact because at the end of the day, we have societal norms, we have the law that tries is that situation, then there are various theories, there's ways of, ensuring that what society, at the end of the day, we make laws to protect or what we make the laws to achieve. The judges must be able to interpret the law in a way as to satisfy what we need as a society at any point in time, because essentially that is why laws are made in the very first place. And therefore, like I said, the only thing is for us to do or endeavor to separate, do as much as possible to let our leanings towards particular things subside so that we have the national interest at stake insofar as a particular law on a subject is concerned. And that's why even judges at some points in time may overrule themselves. We have allowance in the law for all of these things to happen. So like I said, the characterization that Justice Atuguba is making of possibly leanings of judges, their political leanings, it cannot be done in isolation. It cannot be stated in isolation. It may as well apply to him because, see, those are the silent things that nobody sees or nobody can talk of. But at the end of the day, when a law has been made, we try to look at the objective factors. We try to look at the decision that has been made. We try to look at the law. We try to look at the evidence that has come before the court. And then when the decision has been made, we can agree or disagree. There are only three things which will go into every judgment: the fact of the allegation that came before the court, the evidence that came before the court, and the application of the law to the facts and the evidence, which would then give a
All right, we're still struggling with this connection. We'll
it's
try
more
to
likely to be leaning towards what the law says or what the law requires.
Hello, Mr. Paintsil, are you there? All right, we'll try to get Mr. Paintsil back via phone so he can make his contributions seamlessly. Mr. Paintsil, can you hear me now? All right, so this conversation we're having is on the back of... If you can hear me, do go ahead, Mr. Paintsil. We lost you for about some 20 seconds. Kweku Paintsil is a lawyer. He joins this conversation. We'll try to reach him via phone to ensure that we can have a smooth, seamless conversation without all the hitches, so that we can actually have those interactions with him. It is on the back of former Supreme Court Justice William Atuguba, reflecting on our national life, talking about the legal system, the Supreme Court of which he was a part only a short while ago, some of its rulings, things that have been done, and things that he feels ought to be situated in the proper context to ensure that that third arm of government, that glue that cements all the other facets of our national life, stands the test of time. And he's also been talking about political leanings as far as the judges are concerned, or some leanings towards certain angles. Kweku Paintsil, can you hear me now? Can you hear me, Mr. Paintsil?
Yes, please. Yes, please.
All right, please go ahead. You are making a submission, and then, unfortunately, we lost bits of it.
That even though we have these leanings and we are influenced by all kind of factors, where we grew up, the people we are associated with, when you sit as a judge, you are required to suppress those leanings and have the national interest as far as they are reflected in the laws that we have in the country at heart. And then what it means is that at the end of the day, giving an interpretation to a piece of law requires a combination of all kinds of factors, but at the foremost of every judge's mind or every lawyer's mind, as I've said, are three things. First, the fact, the allegations on the basis of which somebody is seeking a release, and the allegations on the basis of which somebody is resisting the release, together with the evidence that stands before the court. What it means is that you can have a very good case, but you can still lose your case if you fail to adduce sufficient evidence. And what it means, for instance, is that a judge cannot even help your case if you appear before the court and you begin to falter or unable to marshal the necessary evidence. And it is the combination of these two that the judges would apply the law. By application of law, we mean the statutes that we have in this country. We are talking about the common law, which is the judge-made law. The common law is the most fluid of all laws, because what happens is that the judges at every point in time have to make decisions and determinations based on the changing circumstances of the time. And what it means is that because society is changing, new courses of action are always arising, some of which have never been documented, some of which there are no laws. But once you come before the court, the judges have a duty to do their best to give the best decisions that they can, having regard to everything that comes before the court. And so it's a very fluid concept, but so far there's no doubt or there's a lot of certainty in the law, so that at every point in time, that's why we have concepts like precedent and so forth and so on. Judges are bound by their previous decisions founded on the same facts and possibly evidence, or same or similar facts and evidence. So at the end of the day, there has been no earthquake in our judicial system. We keep on having law. Once in a while, decisions are made that are embarrassing. Once in a while, decisions were reakoto and so forth and so on. But even the good thing about reakoto and the rest was that it was an interpretation of the existing law in place, which had been put in place. And even though the content of the law was said to be bad, and let me use that expression, the judges did no wrong when they interpreted the face of the law to put those people in detention, which was what the law said. And so if there's a hue and cry about reakoto, for instance, up to date, nobody is accusing those judges of doing the wrong thing. They only interpreted a law which in content was bad or was poor or was oppressive.
Right. So they merely gave their interpretation of the existing law at the time, which judges are expected to make anyway. But in some instances, of course, they must expand it and look at the spirit of the law. So you disagree fundamentally, just to move away from this point, you disagree fundamentally with Justice Atuguba when he talks about the James Gyakye Quayson issue and the fact that the decision was scandalous. You disagree?
I don't accept that position that my Lord has taken at all. I don't accept it. And like I said, it's only reigniting a debate which is spent. That debate is spent. And it's only telling us that all my times that we're having that debate, he didn't have an opportunity to factor in his views. But if he had done so at that time, we would have been over with it. So it is old wine in new, is it what new wine in old bottle? If that's the way I want to put it.
I see.
Yes.
You say it's spent though, but is it without proper reasoning? You say it's spent? Is it because it is not grounded on law? Is it because that the sentiment he expresses on the James Gyakye Quayson issue cannot pass the legal test? I just want you to confirm.
No. Let's put it this way. At every point in time, not only judges, lawyers, everybody. We disagree on all issues, and every time that there's contentious issue, it's when the matter goes to court. In the particular case of Gyakye Quayson, there was unanimity. In other words, the judges were so unanimous. When you read the judgment, there's no doubt the fact that they were the same facts and the evidence that my Lord is oppressed. I know my Lord. There are two judges. There's one particular case that I did before him, before the Supreme Court. We were the non-dissenter in my favor. And therefore, these things are there. Today's minority judgment may be the majority judgment another time. That's why judges are required to record their views in these matters. But the long and short is, once a decision has been made, in this case by unanimity, in other words, all the judges agree, it is very possible that if he was on the bench at the time was part of the judges, he would have dissented. But his dissent judgment will remain for the record. But we must always move forward. And therefore, a dissent judgment does not mean that it's not properly grounded in law. It's only a question of time before possibly these issues may come up again. In other words, maybe 4 years from now, another person will go and pick nomination forms when he has not, renounced his citizenship to a country, then he will wait about election time, renounces it, and then this issue or this debate will be reignited. In other words, at that point in time, must Justice Atuguba's view raised, or the judges will go back to their own judgment. And that's what it's going to be. That's why I say, but it's not out of respect for the views. His views are very solid in law. He has different arguments. He uses different ways to reach a different conclusion. And that must be accorded the necessary respect. But one thing that we all must appreciate is that once you're in a minority, you're in a minority. And for that moment, it does not even mean, for instance, that the majority decision is always right. There have been majority decisions that the same court sitting at a different time have, disassociate themselves from. It's very interesting how the law operates. But, that's why I keep on making the point that much respect to what he has said, but he's in the minority. I fundamentally disagree with him on the sole point that anybody can stand for elections at a certain point when he holds allegiance to another country. At that point, that's the definition. The fact that he subsequently renounces the allegiance up to the point that he is ready to stand for elections and whatever, with respect to him, is irrelevant in my view. And there's a good reason why, for public policy reasons, we must not allow, must not permit, we must not encourage people to do that.
All right. So
there are good policy considerations.
On this point, though, he talks about the fact that the appointment of judges should be done on merit, solely based on merit, not any political attachments and or considerations, and that does not augur well for the image of the judiciary. And as far as the apex court, now there have been claims about people with many political, even partisan colorations who have contested for X or Y party before, now being appointed justices of, the courts, and he finds that problematic. Do you find it as problematic as he does, considering that we are all political animals?
The problem about this country, including Justice Atuguba himself, and let me be very pointed, we all know that that is the criteria. In fact, in our constitution, in everything that we have, there's no other criteria but the fact that a judge must be above reproach. A judge must not have politics. A judge must meet the merits, and so forth and so on. And therefore, if at any point in time you raise this kind of issue, as ex-President Mahama has been doing in recent times, you must come out with a fact. Tell us the evidence that you have to show that we are not doing that. You see, the big problem I personally have in this country is that we make big statements. You are a journalist. In other jurisdictions, we have something we call fact-checking, or what they call fact-checking. You check facts. You make an allegation, and you provide the evidence. Mahama said over 200 or so judges have a very sweeping statement. He could not isolate one judge to say that this judge was appointed for his political leaning. And these allegations, in my view, are scandalous in the sense that we make very general statements without proof of any of it, which means that we are all hypocrites as a country.
Let me just interject here. I'm sorry, pardon me, but let's say this person, for example, has stood as a candidate for a political party, wanting to become member of parliament, or has held some position, or has wanted to be in top leadership of the party, whether regionally, at the constituency level or at the national level, okay? So this is someone who is a known figure within the party while being a lawyer. And this person is appointed to, any of these courts as a judge. Is that right? And let me also link that to some studies that have been conducted, which suggest that indeed the rulings of our courts, the higher courts, seem to express some leanings towards the appointor, or which administration appointed them. How do you react to that?
I'll put it this way. It is only in Ghana that we have raised these arguments beyond the pale. I'll put it this way. One of the brightest judges on the Supreme Court, more proficient, writing more judgments than possibly any of the judges in the Supreme Court, is my mate. He's called Justice Kwame.
Oh,
he was the
right.
General Secretary of a political party. He was brought to the bench by the NDC. But all judges are unanimous that he is delivering beyond what is normally even expected of an ordinary judge. He is virtually leading in the writing of judgment. I'm not saying other judges, and nobody taxed him with any political leaning. That is what ought to be. I sit here, let me tell you what, I'm sympathetic towards the MPP, and everybody knows. But if I become a judge, which I never want to be, with due respect, I have enough conscience to know what to deliver to this country as a country. And see, the kind of interpretations and the kind of drawings and the kind of symmetries that people have drawn between judges' previous political leanings and their judgment. I do not know whether it is a science and not a coincidence. Because I have views on every subject. We disagree. You never saw two lawyers agree on any issue, but a judge will eventually make a determination. And then it goes through the science. In other words, from the High Court, even when you come out magistrate court, then depending, it comes to Circuit Court, High Court, Court of Appeal, Supreme Court. I mean, there are times that we believe a particular judge is biased and so forth and so on. But when you're going up, you cannot really accuse of all the judges of being biased, all the judges of being whatever.
And that actually reminds me of Justice Bafo-Boni, brought in, by the MPP administration, so to speak, because it was during that tenure. But when it came to the election petition, he actually was one of those voices that led to the decision that was arrived at, retaining President Mahama as leader of this country, if you recall. And at that time, I do recall that some people felt aggrieved, stating that, well, it was the other party that had brought him in, and his decision should have counted on that side. But that was not the case. So at least we have example as well, ample example of those who have come in from one administration or appointed by an administration, but who have not necessarily toed the line of any thinking specifically leading to that administration. And you've mentioned as well that if you ever became a judge, you would have enough good conscience to rule in the interest of the country, which is paramount. So yeah. I believe... go ahead.
If you haven't said that, let me push in something. For instance, the paper that my Lord Justice delivered was supposed to be a reflection and comment on the judiciary. Is it suggesting to us as Ghanaians that he never found one good thing that the Supreme Court has done over the period to cite, to balance everything that he said? Why must he concentrate his fire on all the things that he disagreed with the Supreme Court? Is he suggesting that, so this is a reflection of the fact, with due respect to him, that his presentation, in my honest view, was not balanced.
What was what?
It was not balanced. You cannot.
It was not balanced.
Yes, because you cannot be part of the Supreme Court which you have left, and when you have an opportunity to talk about the work that it does, all that you do is to cite all the negative things that, in your view, reflect poorly on it. Is it suggesting to Ghanaians that it's only the wrong things that he sees in a presentation to a country about the performance of the highest court of the land?
Someone would also suggest, I mean, we have the creation of certain courts, descending to the lowest levels to enhance, the delivery of justice. We have the use of, virtual avenues, so many developments, technology and all of that have enhanced the law. But some would say that those are things that are already in place, fast-tracking judgments and all of that. Those are things that are positive, but are already in place. So to tackle the other issues, we need to see a highlighting of the negatives, which is what he did. I've heard that argument as well. Don't you feel that was what he was doing?
You see, that does not reflect well on us as a people. You are a retired Supreme Court judge. You are a statesman for that matter. And when you come to present a paper on the role of the Supreme Court in our present dispensation, please, in fairness, find one good thing that they have done. And please, we are not talking about these logistical, administrative things, burdens, and whatever. We're talking, he was analyzing the content of judgments that they have delivered over the period. Does he read only the ones that have negative things to do? Are we so, this reflects very poorly on all of us as Ghanaians. That when you get up to criticize somebody or you talk about somebody, all that you can do is to say the wrong thing the person has done.
But that also brings to mind a few things. I remember, for example, when Sophia Kufo, who actually was a Chief Justice at a point, also, when given the opportunity on some matters, seemed to have suggested, not just with the pensioner bondholders, that certain things were not going well. So it makes me wonder, is it that when you are there, and of course you must exercise decorum, you must reflect before you speak, but is it that when you're at that level, there are certain ills, malaises in there that you cannot speak of, yet you only have to get out through retirement before you can espouse those views? I mean, when he talks, for example, about the fact that he puts forth a reasoning, his decision on this James Gyakye Quayson case, and after that, for about 6 months, he is not impaneled, which is not what usually would have happened, and that there's politics at play. Can you begrudge him?
I want to draw a distinction. When you are a judge, you are not God, but in fairness to your job as a neutral judge, there are many, many, many things a judge ought not to do. A judge cannot do. You cannot comment on social issues. You cannot comment about whatever views you have are yours. But once you come out you are freed from that bondage, if I may put it as bondage. And then you are free to comment and talk anyhow, reflect, your position on matters. By my problem that I have with the presentation done, was that you had a golden opportunity to assess the work of an institution of which you were part. This is ex post facto, after the event. You are no longer a judge, so you are free. And I expected that he would devote one paragraph to one good thing he believes the Supreme Court is doing well by way of shining light in a dark spot. But all that he does is to bring us negative things. And when I listen to him and I hear him the way he made the presentation, which is all over the place, it's like that institution may possibly even be killed. And when you do that kind of thing, you raise prejudice against a vital institution that we have in this country.
Right. So you feel it wasn't balanced. It may also stem from the tide. He actually reflects something that I have also read and been told about, that this country at its independence was dedicated to the Immaculate Heart of Mary, the Sacred Heart of Jesus, and that the expectations were so high, but that we have been faced with mishaps. He says here, against this background, where Ghana stands now is a cause for grave lamentation. And then he goes on to talk about Ghana being heavily blessed in terms of natural and human resources. Yes, for example, now facing this economic and social hardship and turmoil. But having situated that, I also want you to look at this. The Judicial Council. He points to the fact that the strong presence of the executive arm of government, the executive branch of government, on the Judicial Council doesn't make it independent. What's your reading of that? Do you agree with him?
The very interesting part of most of his presentation was that he was only reflecting and commenting upon things that we Ghanaians chose ourselves consciously. Because he's talking about constitutionalism and all of that.
But wait. So when you say chose, I'm sorry I have to interject, but sometimes I need clarity. Chose intentionally, you are referring to the Constitution, right?
That is so.
Okay, but the Constitution, we are all, unless you're one of those who feel nothing is wrong with the Constitution and has to be changed, there has been a lot of debate, even on the back of the 2010, Constitutional Review Commission. So if you look at it, while it may be there in black and white, are these things we ought to be looking at changing? You can reflect on your earlier point and then get to that as well.
No, I agree with you, but you see, the real point I'm making is that, beginning from 1960, we chose a purely presidential system of government, and then it collapsed. Then we brought parliamentary system of government. Then that also collapsed. Then we chose a hybrid of presidential and parliamentary, which has been carried into the 1992 Constitution. Some people got the feeling and the impression that if the president had an opportunity to have some of his ministers also in parliament, then of course it would feed upon his, interaction, involvement with parliament and so forth. That was an idea that we thought as Ghanaians that was brilliant. And that was an attempt to, for instance, I've always reflected that if we're, for instance, having a parliamentary system of government, as it is done in Britain, where the prime minister's questions, I'm really wondering whether, for instance, our president, if he was a prime minister, he would really have the energy and the time and everything to be going to parliament to answer parliamentary questions and stuff and so forth and so on in an African setting. So therefore, if anybody after all these years comes to a position that, the way we're operating this thing is not working fine, and we think that it must be done this way, it's a fair point.
Yes, but I'm asking you on that same point. Do you feel it creates some problems for the system, and it's something that ought to be looked at? You as a lawyer, what is your thinking on that?
I will put it very bluntly that the system of legislative independence, in the sense that all parliamentarians must be parliamentarians and play no executive role in the executive side of government, is one that possibly may not work too well for an African country like Ghana. And I believe that the interaction between the president and parliament in terms of some of members of parliament being ministers and so forth, I think for me has worked so well. At the end of the day, it is not the idea of strict independence. At the end of the day, whether independence or not, we must work out what we call a system of checks and balances, so that within the uniqueness of the constitution that we have, we may begin to look at putting in structures that will ensure that even though they still remain on the executive side of things, Parliament as a whole will be able to work in a way as to complement or not to complement the president, but for the interest of Ghanaians as a whole. Because, I mean, there were good reasons why we chose that. And the fact that we worked for it up to this point, nobody has given me a good reason. You see, when you talk of parliamentary independence, what is parliamentary independence supposed to work for us as a country? It is what we derive from that independence. This is what, at the end of the day, we are looking about. Because, see, when you look at the American system, the way it works, I'm not too sure any country has been able to replicate it in the same content as they have it there. And what we have is a unique Ghanaian setting. And it is within the uniqueness of what we have that we must begin to learn, based on the lessons we have learned so far, how to make it work better because of the changing circumstances of the time. But if parliamentary independence is intended to mean that we must have a strict separation of parliament from executive, I'm afraid that I don't really believe that doing that by itself will solve the kind of developmental issues and problems that we have as a country.
Right.
So yes, I've answered that the system we have is not bad.
Right.
We have to look at what changes we need to bring. That is what I think.
Let's wrap on these few points. We have just a few minutes, very limited time. I want you to squeeze in. He talks about the fact that the most senior justice of the Supreme Court, in the absence of the Chief Justice, should act in his stead. And you know why he is saying that. But he also talks about ethnocentrism or ethnicity and cronyism not being benchmarks for selecting judges. And he disagrees with any such selections if they are based on those. He disagrees with former President Mahama only, as far as this judicial thing is concerned, only in terms of the partisan balance that has been threatened. That, look, you people also, make yourselves available for these positions so that you can occupy these positions. That partisan balance is not something that will augur well for the country. I'll not get into the Galamsey bit because it will take us away from the main point. What is your reflection in essence then on these points and how moving forward we can sanitize, so to speak, our judicial system? Because if it works for Ghana, and if it doesn't, we all know in the past what that has led to. Those will be the final areas I want you to reflect on as we cap off this conversation.
It's very difficult to disagree with people, with what they claim is not right and whatever. That's not the issue for us as Ghanaians. There are many areas of our life, both political, even I myself have massive problems with the judiciary. I have massive problems with the General Legal Counsel. I have massive problems with our areas of politics and so forth and so on. But the real issue is, having identified the problem, what is the solution? What do you specifically propose? Those are the battle of ideas. That's what we are fighting for. Because, people have different ways of reaching the same goal. So if all that we have to do is to fight and to list all the ills in the society, come on, we can spend one complete week just listening them one by one and will not have ended. But the real issue is we take the problem.
Okay.
Like, for instance, this is independence of the judiciary, independence of legislature and executive. What is his specific proposal? We had the 1960, we had the 69, we had the 79, we had the 92. All of them went about this issue and tweaked this in various ways to reach where we are.
Right.
He has had the benefit of sitting in the Supreme Court, going through all these constitutions, looking at what goes on in other countries. He should come up with a formula.
All right.
Don't forget that in this country, we have toyed with Unigov. We have toyed with all kinds of proposals that people bring. In Nigeria, they form two political parties, force people to join a queue to vote in all kinds of ridiculous things have happened in Africa. But it's not a listing of those ridiculous things. It's a way of moving forward. It's a way of specific suggestions. That's the way we can move this country forward. So it's not like I disagree with him at all. Though I appreciate that if you don't have the power to move things yourself,
okay,
but you have the mind, you have the to bring the suggestions. You should put the problems and the suggestions together.
All right. Thank you, Kweku Paintsil. Thank you. Kweku Paintsil, thank you so much for joining the conversation this morning. He's been sharing his thoughts, reflecting, ruminating on what Justice Atuguba has been sharing with my colleague, Raymond Akwa. Well, before we get into our next conversation, and our next conversation, by the way, is going to be all about our brothers and sisters in those affected areas as far as the spillage of the Akosombo Dam is concerned. Today we focused on their financial state, we focused on education. Today we're focusing on health, how their health has been impacted. When I interacted with Maxwell Lukuto this morning, he was talking about the fact that even some of the water that some of them use to have their baths or to bathe is giving them irritations on the skin. How are we going to deal with the health complications, the bilharzia that he says has, broken out in some places there? We'll be bringing you that conversation up next with Bernice Abubedu-Lanta. But before I go, I'm going to be telling you what I'm going to be doing once I get off here. I'm going to find some Awake purified drinking water, because water is life. Awake is also premium purified water treated through a strict purification process to ensure that every bottle on the market refreshes you better. Now, Awake has the perfect sizes for all purposes. 330 500 ml bottles as well to fit your pockets and bags, 750 milliliters for the heavy drinkers, and 1.5 liters for those like me who always want more. But if you're thinking of something that can work for you in your home or at your office, they also have 19-liter jar bottles ideal for those situations. So what's your excuse now? All you must do is drink Awake purified drinking water wherever you go. Choose a bottle of Awake purified drinking water today and get quality hydration. Awake purified drinking water, one for life. Remember though, for every bottle you purchase, an amount is donated to the kitty of the National Cardiothoracic Center. That's the most heartwarming aspect for me, because guess what? These heart diseases and complications are difficult to treat. The cost. So by purchasing Awake purified drinking water, you put something in the kitty to save a life. Awake is another quality product by Casapreco Company Limited. For bulk purchases, just reach them on 0262 351 251. And do remember, this advert is FDA approved. When we return, the Akosombo Dam spillage, the affected areas on our radar. We'll be right back.